Hi, I'm Vicki Hall with Remax Masters Millennium, and I specialize in real estate issues for seniors. And in the process of doing that, I rub shoulders with a lot of other senior experts. And so today we're going to talk to three people here about common questions that we get. We've got Terry Crocker and Mike Pomier from Vicare Solutions. And then we also have Mike Raybon
Yes.
from Mortgage 300, and he specializes in reverse mortgages. So they're going to talk a little bit to start with about the importance of having power of attorneys and wills. So take it away, Mike.
Okay, great. Thank you. I appreciate it. Let's talk a little bit about a power of attorney and what it is and why it's really important. So what a power of attorney does, it gives someone else the ability to act on your behalf if you're not capable of acting. So let's say something happens, you have a stroke or you develop some form of dementia and you're just not able to enter into legal documents. Who's going to do that for you? So if you don't have a power of attorney, then your family has to go into court. They have to get a guardianship conservatorship appointment by the court that allows them to act on your behalf. And that can be expensive and it can take a lot of time. So having a power of attorney allows you to keep from having to go into court. So one of the things that we look for and what we do is all of our time is spent helping families where a family member has experienced a health issue and now they may need some form of long-term care. In fact, if you were to look at the Department of Health and Human Services for the U.S. government website, it'll show that over 70% of all of us that have attained age 65 are going to need some form of health care, long-term health care during
How many? What percent?
70%. So that may be needing some sort of care in your home or assisted living or in a nursing home. And it's expensive. In-home care is up to $30 an hour now. If you're looking at needing full-time in-home care, it's like $25,000 a month. I mean, it's just, yeah.
$25,000 a month.
Yeah, it's...
Whoa. So staying in your home is more expensive.
Well, if you need full-time care, it absolutely is. Now, staying if you end up staying in a nursing home, that's anywhere from $10,000 a month and more. So care is expensive, and a lot of what we do is we help families look at what benefits are available to them that will pay for their care. And one of the ones that we utilize probably the most is Medicaid. And a lot of people say, whoa, wait a minute, Medicaid, just for poor people, it's not for me. And that really isn't true. I mean, Medicaid
That's the impression I've had too.
Oh,
in the past.
absolutely.
Yeah.
And Medicaid is a benefit that's there for all of us because we're all, one fall or one, health incidents away from, needing, care that can be $10,000 a month or more. So, getting back to a power of attorney, one of the things that let's say that you do have a stroke and or you do have dementia. Now you're not capable of handling your own financial issues. Who's going to do that for you? So if you have a power of attorney, you can actually appoint a family member to be able to handle those financial and or health issues for you. And it's important when we're looking at Medicaid that it be the right power of attorney. And the reason being is a lot of times what we do is part of the planning, we may transfer assets to family members. So if it comes down to a choice, would you rather have your family get your assets or the nursing home get your assets? most people say, no, I'd rather have what took my whole life to put together go to my family. And so in order to do that, there has to be a gift. Well, a lot of powers of attorney either don't allow for gifts, or they limit gifts to the annual IRS exclusionary amount, which is $15,000 a year. So we can't do a whole lot of planning with that. So you really need to have a power of attorney once you become, once you're a senior and you're starting to think about, what's going to happen, in the future. You need to have a power of attorney that gives your agent the ability to make unlimited gifts for the purpose of, qualifying for benefits such as Medicaid and or other benefits.
So I think I heard that you guys can help shield 100% of a couple's assets and 50% of a spouse.
Absolutely. So, when you're looking at $10,000 a month, we're talking about $120,000 a year. You can burn through a lot of assets in a hurry. And one of the heartbreaking situations that we've seen is where you've got a healthy spouse. Let's say it's a healthy wife. But the husband now needs care, and the husband has to move to a facility. They're spending $10,000 a month, and now the wife, she may be 65 years old. What's going to happen to her? She may live another 20 years. She needs those retirement and the asset benefits. And if they burn through everything, then there's nothing left. So with proper planning, we can actually preserve 100% of the assets for the healthy spouse and still qualify the spouse that needs care to have that care paid 100% by Medicaid.
I bet people think of you guys as miracle workers.
They do. That's probably in a former life. I was a tax attorney, and I didn't get hugged very often. But with doing what we do, people are so grateful because they don't know, they don't know where to turn. All they look at is what's going to happen to me, what's going to happen to my family, when we're spending that kind of money.
Yeah, no, we talked a little bit about the POA. How does the will intertwine with that? Or does it?
Oh, it absolutely does. A lot of people don't have a will, and if you don't have a will, then what will happen is upon death, then your family has to go into the probate court, and then it's going to be the court that determines who gets what assets. And so one of the advantages of having a will is you can avoid all that. You can determine in your will who's going to get your assets upon death.
And is it true the POA dies when the...
That's absolutely
when the
correct,
senior
and a lot
dies.
of people
Okay.
don't understand that. So they think, well, I've got a power of attorney, and now the principal, the person who adopted the power of attorney, dies, and the agent's saying, well, I have a power of attorney, I can go ahead and take care of all of the assets in the estate and get that done, and that's just not true because upon death, the power of attorney is no longer valid.
I ran into that. I had a house listed, and the daughter had the power of attorney. The mother was in a nursing home. In the middle of the contract, the mother died. So we had to go back to probate
Yep.
and appoint the same person as then her executor.
Of the estate. Yep.
So that took a little bit of time
Yep.
to do that.
Now, the term executor and personal representative are synonymous.
Yeah, they're
right?
kind of interchangeable.
Okay. Now, we were talking earlier about someone who has a will, has a personal representative assigned, but that doesn't free them from probate. right?
That's correct. You still have to probate the will. The only real exception to that is if you have a small estate. So there are provisions in the law that allow you to deal with assets. Let's say you've got a bank account and there's $25,000 in the bank account. That's the only asset that's there upon death. You can use what's called a small estate affidavit. I think the limit's somewhere around $75,000 or less, and you can actually fill that out. It's a one page. You just fill it out and say, I'm the person that would receive this this asset under state law, and you can give that to the bank, and then the bank is supposed to pay over the money.
You can answer a real big question for me that comes up occasionally. I've got I do reverse mortgages, so everybody I work with is old, like myself, and
Me.
Older.
older, yeah. And we've got the personal representative is assigned in the will. Of course, there was a POA, but it's gone now. And that person is also the heir or is on title when the borrower dies.
They're on title.
Yeah, on title, and they're the personal representative. So as the personal representative, they can work with the lender to extinguish the loan in whatever way they choose to do that. But if they're on title, is there anything that they're limited from doing?
No, if they're on title, depending on how they're on title. So if the property is titled as joint tenants with rights of survivorship, then what happens upon the death of the other owner, their interest just disappears. So now,
joint tenants.
as joint tenants. And
Okay.
so the surviving joint tenant then owns the property 100%. It doesn't go through the estate, it doesn't go through probate, and so you're fine with that issue. However, if they're tenants in common, then the person dies with that type of ownership, then that is subject to probate. Now you do have to go through
I ran into a situation recently where the mom wanted to put her son on title, and there is one type of being added to title that could be a tax consequence. And I don't, maybe that's for a CPA to answer.
Well, there's plenty of tax consequences, and generally, especially when you're dealing with a personal residence. And so let's, as we know, that if you sell your home, you get to exclude a certain portion of the gain, and it's like
$250,000 for one person and $500,000 for a couple.
So let's say that I own a home, and there's $250,000 of inherent gain there, and so if I sold the home, I wouldn't pay any taxes. But now let's say that I give a portion of my home to my son, and now we sell the home down the road. Now my interest, I get to exclude any gain, but my son, he gets his basis for tax purposes, and I don't want to get too bogged down in this, but his basis is what I paid for the house. So if I paid $100,000 for the house, now he's got some gain he's going to have to pay tax on. So sometimes what we'll do, if we've got a home and we're doing some planning, we may have the children purchase the home rather than, because
Oh, okay,
now
yeah.
when they buy the home,
They have current value basis.
They've got the basis of whatever they paid, and then when they sold the home, if they sold it for the same price, there wouldn't be any tax consequences. So there are ways that you can structure transactions that will allow you to qualify for benefits, and also lessen the tax implications.
Oh, good.
Okay, that was very informative, and I appreciate all three of you being here to help educate seniors on some of the different options, and we will talk about other issues a little bit later. And again, this is Terry Crocker and Mike Homier with Vicare Solutions, and we've got Mike Raybone with Mortgage 300, and I'm Vicki Hall with Remax Masters, and I specialize in real estate needs for seniors. Thank you.